Major breaking news out of the Court of Appeals for the 8th Circuit, based in Missouri, or Missouri, depending on where you're from. Specifically, a decision has come out of that court that says that they will not hear a case called United States versus Jackson en banc, which deals with whether or not laws associated with 18 U.S.C. 922G, dealing with prohibited persons, whether or not they are constitutional under the Second Amendment. This is a blow to the Second Amendment, but it ultimately could give rise to a cert petition and a U.S. Supreme Court decision soon. Let's talk about it when we get back. Hey folks, I'm Mark Smith, host of the 4-Box Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of First They Came for the Gun Owners, the definitive guide of how the anti-gunners will try to take away our gun rights, A to Z, including everything from political violence to red flag laws to retail and wholesale level attempts to disarm us in various ways. Check out First They Came for the Gun Owners if you do not already own a copy. All right, breaking news here. United States versus Jackson, 8th Circuit Court of Appeals out of Missouri, central part of the country, including states like Minnesota as well. Bottom line is this. There was a 3-judge panel decision in a case called United States versus Jackson that essentially said that a felon in possession law under federal gun control statute 18 U.S.C. 922 G1, that statute was constitutional under the Second Amendment. There was a petition for the 8th Circuit to hear the case en banc, which means that the entire 8th Circuit Court of Appeals would hear the case, and not just the 3-judge panel. Many of you are familiar with the en banc decision-making process in the 9th Circuit Court of Appeals out of California, where a 3-judge panel will issue a favorable ruling in support of the Second Amendment's right to keep and bear arms. And then there will be an en banc decision by the entire 9th Circuit. It will reverse it. That was the way it went in the 9th Circuit for many years. We'll see if that continues accordingly in the 9th Circuit. But today we're talking about the 8th Circuit Court of Appeals in the center of the United States. So the 3-judge panel ruled against the Second Amendment, saying that 18 U.S.C. 922G did not violate the Second Amendment, but there was a request for en banc review. That request has now been denied. It has been denied, which is bad news. However, there is a powerful dissent by 4 judges on the 8th Circuit, and this is important. The 4 judges were all appointed to the federal bench by none other than Donald Trump. Those are the 4 judges who dissented and said that this case should be heard en banc, that they thought that the panel decision could have been erroneous and may need to be reversed, especially when you're dealing with what are known as applied challenges. Just as a quick review, when there is a facial challenge to a statute, the claim is that the statute can never be constitutional under any set of facts or circumstances. An as-applied challenge to that same statute is specific to the person challenging the law. So a facial challenge to 922 G1 dealing with felons in possession, saying that if you're a convicted felon, you cannot possess firearms. A facial challenge to that law would say that under no set of circumstances that 922G provision of federal gun control law constitutional. A as-applied challenge would be the sort of thing we saw in the 3rd Circuit Court of Appeals out of New Jersey dealing with Brian Range. If you recall, he won his case a few months ago where Brian Range was convicted of a state misdemeanor for alleged welfare fraud like 20 years ago for failing to disclose, I think, lawn mowing income or something like that on a welfare application. He was convicted of a misdemeanor. He was then disarmed under 18 U.S.C. 922 G8. I should say G1, because technically speaking, he could have been sentenced to more than 2 years in prison under the statute he was convicted of, even though he did not serve a day. But the 3rd Circuit dealt with an as-applied challenge by Mr. Range and said that even if 18 U.S.C. 922 G1 could be constitutional under certain circumstances, it is certainly not constitutional for disarming Mr. Range permanently for the rest of his life because he's a nonviolent felon. Thus, with that in mind, the 8th Circuit Court of Appeals was asked to hear en banc this challenge to 922G on behalf of Adele Jackson that said that this law is unconstitutional as applied to him. The 8th Circuit decided ultimately not to hear this case en banc. Mr. Jackson lost in the panel. Then the request was made to hear it en banc. It was then denied. But there's this major dissent, and I want to talk briefly about this dissent by the 4 Trump-related judges who were nominated to the bench by the President of the United States, Donald Trump. Specifically, what they said was they thought that this case was appropriate for en banc review because the panel apparently made a series of mistakes. The first thing that the three-judge dissent from the en banc decision, the first mistake they thought the panel made was it flipped the burden of proof. As you recall, under Nysurpa versus Bruin, once the text of the Second Amendment is implicated, which obviously it is if they disarm you for life, you can't have a gun for the rest of your life, that clearly implicates the text of the right of the people to keep and bear arms because you can't keep it if you can't possess guns. It implicates the text. Once it implicates a modern-day gun control law, implicates the text of the Second Amendment, you all know what happens. The burden shifts. The burden shifts to the government to demonstrate that the modern-day gun control law they're trying to uphold is consistent with long-standing, going back to the time of the founding, gun control regulations that existed all the way back to the time of the founding throughout our American history. But again, the burden is on the government. So here are the four judges in the Eighth Circuit that were upset that en banc review was not granted, said that the panel made a mistake by shifting the burden to Adele Jackson, as opposed to forcing the government to come up with actual analogs. Now, what really happened in this Jackson case is the panel simply quoted ad nauseum, as I see it, a line from the United States Supreme Court decision in Heller, specifically this line that says, quote, nothing about the Heller decision or the Second Amendment, quote, should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons, period, close quote. Now, that was not necessary to decide the Heller case, which was simply the question of whether or not you could ban people from having handguns in their home, unlocked, loaded, ready for self-defense. But there was that passing reference there, but the court never actually decided whether or not the bans on felons in possession were constitutional. They had a passing reference, which is often referred to as dicta, as opposed to the holding. And what happened is the Eighth Circuit Court of Appeals panel, the three-judge panel, basically embraced the Supreme Court's dicta in Heller and said that's the law of the land. But they failed, the panel failed, as I see it, to do the actual work necessary, because even though that language was in Heller, they hadn't done the actual analogical work, the actual analogical reasoning, and that was what the Eighth Circuit was supposed to do, but the panel did not do that, and that's why these four judges appointed to the federal bench to the Eighth Circuit by Donald Trump are coming out and saying, stop, this was wrong. The entire Eighth Circuit needs to review this entire decision en banc because it's clear that the burden was shifted to the individual American citizen, Ms. Adele Jackson, as opposed to the burden being on the government. Because just like in a criminal case where the burden of proof is on the government, the presumption of innocence applies to the American citizen, so too with modern-day gun control law. The burden is on the government to show that the gun control law is constitutional, and if they cannot do it for any reason, the government loses. When in doubt, toss it out. As I like to say, when in doubt, toss it out when it comes to modern-day gun control laws. If there's any doubt about the constitutionality of a modern-day gun control law, it should be tossed out and not enforced. And that is not what the three-judge panel in the Eighth Circuit did in this Jackson case, and that's why these four judges were dissenting, saying we should hear this case en banc. It is a mistake not to do it. Now, the four judges that were upset that en banc review is not granted, this is what they wrote in their dissent. They said, the decades surrounding the ratification of the Second Amendment showed a steady and consistent practice. People considered to be dangerous, lost their arms, but simply being a criminal had little to do with it. And this goes back to the question we've often talked about. Why is Martha Stewart disarmed for life? She was convicted of lying to the FBI and has never shown any danger to anyone in any respect, no evidence of violence, no evidence of dangerousness or anything like that, and yet Martha Stewart is disarmed under 18 U.S.C. 922 G1 for life. So why should Martha Stewart lose her gun rights for life? That is really what these four judges in the Eighth Circuit are asking. It doesn't make any sense to them because the only historical analogs that might apply suggest that you can take guns away at the time of the founding for people that were violently dangerous, but not simply for failing to comply with the law. Now, as you know, what the anti-gun movement wants in America, and we saw this in some briefs they submitted in the Rahimi case, they want to create either a virtuousness standard or to claim that if someone is not law-abiding and responsible as they define it, they can take your gun rights away, which means if you do not recycle, if you jaywalk, if you speed over 5 miles per hour over the speed limit, all this stuff means you're not law-abiding, and they want to be able to deny you the ability to have guns if you're not law-abiding or responsible, and they want to define it broadly broadly, and they want to be the ones that define it so they can take as many guns away from as many people as possible. But this is what the 4 judges in the 8th Circuit are saying, that is not the standard. The Second Amendment demands the only way you can disarm someone is if they are violently dangerous. If they're not, guess what? They don't lose their gun rights, and they think that the 3-judge panel got that wrong as well. Now, there's 4 historical analogs that the 4 dissenting judges here flagged, and it's quite interesting because none of them really support 18 U.S.C. 922 G1. Let me show you. Specifically, they talk about 4 historical laws at the time of the founding dealing with the disarmament of Native Americans, the disarmament of slaves, disarmament of Catholics, and disarmament of loyalists. But if you think about these 4 categories of laws at the time of the founding, none of them justified taking guns away from felons generally in the modern world. Why is that? If you think about it, well, Native Americans were not actually American citizens. The Second Amendment is about the right of the people to keep and bear arms. The Native Americans were viewed as foreigners, right? They were considered not Americans, so they were never able to benefit from the Bill of Rights or the Second Amendment because they weren't part of the people, consistent of the right of the people to keep and bear arms. Because again, it'd be like saying that, people that lived in Paris, France had a Second Amendment, or people that lived in Tsarist Russia had a Second Amendment pursuant to the Bill of Rights. That's obviously not true because they weren't Americans. And at the time, Native Americans were viewed as not Americans, and thus they were not part of the people, as in the right of the people to keep and bear arms. So that's the first historical set of analogs that I think were discussed here, but obviously do not apply. The second one is the slaves. We also know that the slaves were viewed as not citizens. Best evidence of that, of course, is the early 19th century decision in Dred Scott, which was discussed in various Supreme Court cases, including but not limited to, of course, Clarence Thomas and Bruin, who says that the Dred Scott decision demonstrates that Americans had the right to carry guns outside the home because in that decision, the infamous decision of Dred Scott says that obviously blacks were not citizens of the United States because if they were citizens of the United States, they would have the right, like other American citizens, to carry firearms everywhere they went. That was the decision by Chief Justice Roger Taney of the United States Supreme Court in Dred Scott. Clarence Thomas used that quote in discussion of Dred Scott in the Bruin case to show that the right to keep and bear arms includes the right to carry guns because the right to keep means the right to possess and the right to bear means the right to carry. And of course, one of the reasons to say you have a right to carry guns outside the home for self-defense or other lawful purposes is Clarence Thomas's discussion of Dred Scott. So again, the fact that, banning slaves from having guns is not an analog to deny Americans the right to keep and bear arms because, again, they too were viewed as foreigners on par with Native Americans in that sense. Then there's a discussion of the Catholics, that there were times where the Catholics were denied the right to keep and bear arms. But again, at the time of the French and Indian War and during those related topics, those related time periods, the Catholics were viewed as potential threats to team up with the French. Remember, the French were Catholic, the English were Protestant. So the idea was that some of the Catholics might team up with the French because back early on in American history and back in English history, there was the long-standing battle between the Catholics and the Protestants. And again, banning the Catholics was viewed, again, as really a wartime measure to some degree because the Catholics of America were viewed as potentially ganging up or teaming up with the French to fight the rest of the United States at the time. This is, of course, before the founding. But that was another set of analogical laws that were discussed. The other one, of course, is the Loyalists. At the time of our founding during the American Revolution, if you did not swear an oath of loyalty to the Patriot cause, you were viewed as a Tory, which meant that you were supportive of King George III, and thus you were basically a danger because you were, Americans were fighting the British in a revolutionary war, in a civil war, if you will. So if you would not take the oath to support the Patriot cause, you were viewed as a Tory. And of course, you were basically on the other side in the context of a war. So again, none of this really speaks to the issue of a modern American civilian being disarmed because of a violent crime that was committed. And these are the kinds of analogs that this 3-judge, the 4 justices dissenting says that we need to be able to analyze these and evaluate these in the context of whether or not 18 U.S.C. 922 G1 is constitutional as applied or otherwise. And that is wrong that the 8th Circuit refused to hear this case en banc because there's a lot of questions about whether or not the first panel, 3-judge panel decision of the 8th Circuit, whether or not that was actually correct or not. To summarize, the 4 judges of the 8th Circuit who thought this case should be heard en banc but were turned down, and thus they wrote a dissent, this is what they write in summary. Quote, disarmament is about dangerousness, not virtue. We know that because colonial and post-ratification gun laws targeted rebellion and insurrection, not criminality. There have always been criminals, but there is no suggestion in any historical analog that criminality alone, unaccompanied by dangerousness, was reason enough to disarm someone. And history certainly does not support Jackson, meaning the lower court's decision by the 3-judge panel in Jackson. And history certainly does not support the 3-judge panel's decision in Jackson, unbending rule that felons can never win an as-applied challenge, no matter how nonviolent their crimes may have been or how long ago they happened. When you're looking at challenges to 922G1 cases, remember there's sort of 2 separate but related but separate categories. There's those people that have been convicted of crimes that could never have been disarmed. These are people, for example, that perhaps committed a nonviolent felony or a nonviolent misdemeanor who could have gone to prison for 2 years, but they should never have been legitimately disarmed. They never could have been legitimately disarmed because the crime they committed had nothing to do with dangerousness. This might be the Martha Stewart problem, where she's convicted of lying to the FBI, but has never hurt a fly that I'm aware of, and there's no evidence of violence in Martha Stewart's past, so she should not be disarmed once she serves her sentence for lying to the FBI, because that's the kind of thing that you should never be disarmed over because it doesn't speak to violence or dangerousness. So that's like one category that I think the 8th Circuit did not come to grips within the panel decision. The other category is that there are instances, as I see it, where persons could be validly disarmed at one point in time. Maybe it was legit when they're disarmed at the start of some process, but today they are no longer dangerous. So I think this would be a situation where, let's say, someone at the age of 18 committed a robbery or did something at the age of 18 that was violent and deserved to be disarmed because they did something violent or dangerousness. But then all of a sudden you wake up and they're 55 years of age, let's say, and they haven't done anything wrong since then. Well, there's a very strong argument that they're no longer dangerousness, or I should say they're no longer dangerous. And as a concept of them not being dangerous, they should be able to get their rights back. So again, the first category, as I see it, is people that never should be disarmed because the initial crime they committed was simply not enough to take away your gun rights, i.e. the Martha Stewart thing, where you commit a crime that has nothing to do with dangerousness or violence. The other category is, yes, maybe the person committed an act of dangerousness or was violent at one point in time, but enough time has passed where maybe they are no longer dangerous or violent because of the passage of time. Again, these are 2 distinct conceptual categories of scenarios that may or may not be constitutional under 18 U.S.C. 922G1 that I think the dissenting judges wanted the 8th Circuit to grapple with, but because they did not grant en banc review, that's not going to happen on the 8th Circuit. But I suspect what's going to happen here is Jackson's attorney is going to seek certiorari review to the United States Supreme Court, and I could see this case possibly being granted cert after the Rahimi case and dealing with the constitutionality of 18 U.S.C. 922G1, which again, felon in possession, which is different than the Rahimi case, which is 922G8, dealing with those people subject to a domestic violence restraining order, and during the content, or I should say during the time period when that restraining order is in effect, them being disarmed. Again, related to 922G1, but certainly different, with different analogs and different considerations. We'll see if the Supreme Court takes on another case involving 922G after they deal with Rahimi, which of course they're dealing with right now. All right, folks, hope you learned a little bit something here today. If you haven't subscribed, please do so. Make sure you like this video, and don't forget to follow me on Twitter at 4Boxes Diner, and we'll see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.